We are here today because of a tragedy that should have and could have been avoided. As a result, life in this world of Andrea Hudson, Boy Buster Brown, Matilda and Eloise Wilcoxon were cut tragically short. Two others, Nolan and Charlotte Hudson, were seriously injured and who will endure pain that shall not be ignored. In an instant moment, the lives of these families, friends, schoolmates, teachers, mentors, neighbors, soccer teammates, running partners, and first responders were shaken and altered forever. The folder of letters that I received, the comments today, the photographs, the video, demonstrate the pain and speak of pain and sorrow and fear and haunts and struggles. And I read about clouds of grief and the holes in their hearts.
This section is powerful. The judge isn't just listing victims. He's humanizing them. In legal settings, this is crucial. It shows that sentencing isn't about numbers. It's about lives changed forever. What details stood out to you about the families?
It is my job, I'm tasked with imposing a fair and just sentence. And I'll try my best to accomplish that. But nothing I do or say today is going to alleviate anyone's pain, anger, frustration, or grief. I sincerely wish it could. But sadly, the law falls short of that promise. What I hope, however, is that the memories of Andrea, Buster, Matilda, and Eloise are not tethered to that tragic event for today's hearing, but how they were described in the letters and the comments today. For example, Andrea, for her effortless boldness, her hilariously authentic self, and as one person described, the coolest person ever. Remember Buster for his laughter, his warmth, light and energy, and his vibrant source of joy. Someone else described, and please remember Matilda for her kindness, her sweetness, and her joyful disposition. And Eloise for what someone described as her spunky and good-natured curiosity. And remember to check in on the well-being of Nolan and Charlotte. It will help them. I have never met these individuals, but through the letters, the photographs, and the comments today, I got to know them. Chase Jones, I got to know a little bit about you as well. From many that loved you, this is what I learned. I learned that you are thoughtful, that you're respectful, that you're caring.
Here, the judge shifts toward Chase Jones, and this is interesting. Judges rarely praise defendants unless it's relevant to sentencing mitigation. Notice how he balances compassion with accountability. Do you think remorse should influence a sentence?
I learned about your difficulties and obstacles at various times through your life, and how you face them with grace, self-motivation, and a desire, someone described as a desire toward self-improvement. I read the letters, and I observed you today, and I do believe that you're genuinely remorseful for this tragedy. We are not defined by our worst moments, but rather how we respond to those moments. And from what I've been told, Mr. Jones, you have the extraordinary potential and drive to be the best version of yourself. And not only learn from this tragic event, but teach and hopefully deter others as well. My advice to you, sir, is I sincerely hope those goals and promises can come to fruition not by words, but by your actions. If anybody leaves this courtroom with a dry eye, including me, having a robe does not make me stoic or lose my humanity. This is tough. It's tough for everybody in this courtroom, everybody. I'm obligated under the law to follow certain criteria and sentencing guidelines. The criteria that I'm tasked to look at to determine a just and fair sentence is whether the punishment for the criminal offense is proportionate to the seriousness of the crime.
Okay, big legal moment incoming. The judge is about to announce the actual sentence. And this is where proportionality, plea agreements, and the law all collide. Listen to the phrase, agreed recommendation. It tells you this outcome was negotiated, not spontaneous.
Does the sentence respect the law by providing a just sentence? Does my sentence or a sentence protect the public? But also, does it offer an individual who's pled guilty an opportunity to improve on himself or herself? And does it reduce the risk of reoffending by protecting the community? I know these lawyers. I've known them for a long time. They're experienced. I know that they took many of those factors and other factors in negotiating and considering what they believe to be a just and fair result. I am going to follow the agreed recommendation and impose the following on counts 1, 2, 3, and 4, 210 months to run concurrent with each other and concurrent with counts 5 and 6. On counts 5 and 6, 84 months to run concurrent with each other and concurrent with counts 1 through 4, 18 months of community custody on counts, at all counts, that will enter in no contact with the families of Hudsons, Wilcoxons, and Browns. Restitution, which my understanding is to be determined at a later date. Is that correct?
That is correct, Your Honor.
And what is your client's position about being present for a potential restitution hearing?
Your Honor, my client would waive his presence.
We'll impose the $50 Title 46 fee, the $500 victim penalty assessment fee, the conditions, the conditions of no moving violations, that you do not drive a motor vehicle without a valid license and proof of insurance, that you do not drive a motor vehicle without a functioning intelligent speed assistant device.
Whoa, hold up. Look at that opening 18 seconds. A mother, a knife, a screaming defense attorney, and a judge yelling stop. This is literally the kind of chaos Courtroom TV loves, but it's real life. Quick legal note, Samantha's facing assault charges, but notice her daughter is already on probation for stabbing her sister. Audience, how does that shift your first impression? Is the mom really the aggressor, or is this more complicated than it looks?
Active mode, and that you complete level 2 of the driving program. Is there anything else that the state believes that I may have missed or need clarification?
No, I don't believe so, Your Honor.
Defense?
No, Your Honor.
Just want to clarify, Your Honor, is waiving the court costs. We did not ask for those.
I'm sorry?
Waiving the court
I
costs.
am waiving the court costs.
This part is fascinating legally. The families themselves don't want a no contact order. That's rare in cases involving tragedy. It signals openness to restorative justice. What do you think? Should victims get a say in post-sentencing contact?
Your Honor, the families actually,
I'm sorry. Somebody may want to talk to you.
families would wish to have you not order a no contact order. They are open to Mr. Jones
Some restorative
contacting them.
justice.
At some point, they are open to Mr. Jones contacting them, and they do not want the lifetime no contact order.
Okay, I suspect the defense has no objection to that.
Certainly no objection there.
I will not order, and that's for all three families?
It's all three families, and if at some point there's some issue, we can always come
Of
before the
course,
court.
of course.
Okay, double check everything that I've done. Okay. Did you sign it? Hmm? Oh, yeah, I wrote it into our, we now have an appendix H. I'll send it to you, Brianna. Yeah. Actually, Your Honor, I'm going to hand up to the court to begin the fingerprint form that was done here in court, and your clerk has given us the thumbs up on the collateral rights and the notice of ineligibility to possess a firearm, and Mr. Chase's loss of voting rights.
Your Honor, we did go through all of those before his signature.
You want them all at the same time? Okay.
Approach.
Of course. It might be easier over here.
And I'm heading forward the judgment and sentence. It appears the court is on its oral ruling.
Thank you.
Pause here. This is the legal heavy lifting. The judge just went through what a protective order actually entails. No violence, no harassment, no weapons, sometimes a 200-foot residential restriction. These orders are serious. They're not just suggestions. And for parents watching, violating one can mean additional criminal charges. But notice how the judge balances protection of the child with not over-penalizing the mom. It's a tightrope act between justice and family reality.
Mr. Jones, before I sign this document, do you have any questions about the sentence that's been imposed?
No.
As the hearing wraps, the judge explains firearm restrictions and voting rights, standard in felony cases. But the clarity here matters. Many defendants walk away confused about their rights. This transparency helps prevent reoffending and future legal trouble.
Signed the judgment and sentence, the Appendix B criminal history. I've also signed the DNA order, the Appendix H of the community custody, the notice of ineligibility to possess a firearm and loss of right to vote, and the fingerprint form. Anything else from the state?
No, Your Honor, I will need to serve Mr. Jones with his notice of ineligibility to possess a firearm. Mr. Jones, you cannot be near a firearm. Washington law interprets that very broadly. Don't be in a house, don't be in a car, don't be near a firearm until a court actually signs an order and allows you to possess a firearm. You are losing your right to vote in this because of this while you are in the Department of Corrections. As soon as you are released from the Department of Corrections, you can register to vote and use that right, even when you're on community custody. It's just while you are in the Department of Corrections. And if that law changes, you'll know about it in the Department of Corrections. I'm serving you with that notice.
Receipt acknowledged, Your Honor.
Anything else from the state?
No, Your Honor.
Anything from the defense?
No, Your Honor. Thank you.
That concludes this matter. Best of luck to everybody.
Thank you, Your Honor.
Good work, Your Honor.
Please rise. Recess.